Greetings, legal minds, and welcome once again to the lecture hall brought to you by Emmy's Legal Nugget. Today, we will be analyzing one of the most important concepts in respect to legal proceedings in Nigeria. Although this concept has not been discussed by many as very important, but when you begin to analyze this particular concept, you will see how paramount this concept is in relation to legal proceedings. This is the standard of proof in Nigerian procedural law. Firstly, if you study the Evidence Act, you would understand that there is a certain level of legal responsibility that is placed on every party to a dispute to establish the validity of their claims or to establish the truthfulness of their assertion. This is to say that when you become a party to a dispute, or as a lawyer who is representing your client, the law lays an obligation on you to prove to an appropriate standard of the claims that your client is bringing before the court. This is known as the standard of proof in legal proceedings in Nigeria, and it can come in two ways. It can either be a balance of probabilities or a proof beyond reasonable doubt. Simply refers to the level or degree to which a party must prove its claims and assertion to succeed. That means in a situation when you accuse someone of stealing your money in a criminal proceeding, there is a level of responsibility placed on you to prove sufficiently to the court that it was indeed that individual who committed the offense of stealing. So, the standard of proof is simply the level of degree that have been laid out by the law for individuals making claims and assertions before a competent court to attain before that assertion would succeed. It is important to note, as provided expressly in the Evidence Act, that the standard of proof required by every party in a criminal and civil proceeding are different and distinct. This means that the level by which you are expected and obligated by the law to prove your assertion or claim in a criminal proceeding is very different from the level or degree to which you are to claim in a civil proceeding. So, in a criminal proceeding, the standard of proof is simply a proof beyond reasonable doubt. But in a civil proceeding, it is known as a balance of probability or a preponderance of evidences. Coming to the standard of proof in criminal proceeding, like we already said, that the standard of proof in criminal proceedings and the standard of proof in civil proceedings are very different. In criminal proceedings, it is a proof beyond reasonable doubt. When we talk about a proof beyond reasonable doubt, we are referring to the fact that in criminal proceedings, parties are expected to prove to a certain level or degree, so much so that the court, the judge, or a reasonable man would not have any doubt that the defendant committed the crime. So, just like the scenario we gave earlier, if you are a party to a criminal proceeding in the offense of stealing, you must prove to the court, and based on the evidences to which you have adduced during the course of the proceedings, it must show that, and it must also be convincing, that there is no doubt that the defendant or the accused actually committed that offense of stealing. This is to say that if there is any atom of doubt in the mind of the judge or of the court that other persons other than the defendant or the accused actually committed the crime, the court would have no other option than to resolve the dispute in favor of the accused, because the degree to which you are expected to prove in criminal proceedings must be one of without reasonable doubt. As stated in the case of Ajose and the State, which was held in 2002, the reason for this is that it would not be right to convict and sentence the accused party where there is still reasonable doubt that other persons other than the accused may actually have committed the crime. But in civil proceedings, the standard of proof is on a balance of probabilities. This simply means that when courts want to determine the validity of each party's claim, courts usually weigh the evidences of parties. And when we talk about the balance of probabilities, we are simply trying to explain that the courts, before accepting a party's claim, must understand that his claims are more likely than not. When we talk about more likely than not in relation to the standard of proof in civil proceeding, we are simply trying to say that a party proving his claims in a civil proceeding must prove to a certain level that the court, after the examination of the relevant evidences, must be aware that the claims of the party in this particular proceeding have a higher chance of it occurring than it did not. So, when a party wants to sue for a breach of contract, he must understand that before his claims can be accepted by the court, he must prove to a certain level that the court would have no other option than to accept these claims, because the nature of the evidence that have been adduced can show that his claims actually occurred than it did not. So, the standard of proof, as we explained, is generally the level or degree to which a party must prove its claims to succeed in every legal proceeding. And the acceptance of a party's claim by a court is actually dependent on whether or not this party has actually attained the level or degree of proof as provided before by the Nigerian law. Thank you so much for your time. Please follow us and subscribe to this channel to be updated with more insightful knowledge and legal tips as sent.